A single alphanumeric code on a social security file, specifically a C1 designation, carries the power to secure a disabled person's livelihood, yet for the son of a Hollywood legend, that exact code became a bureaucratic snare keeping him homeless. The Disabled Adult Child Program, or DAC, is designed to protect our most vulnerable citizens by allowing them to draw ongoing benefits from a parent's work record. We are examining the severe structural flaws, potential legal loopholes, and bureaucratic failures within the system through the documented case of Landon Robinson, whose father was the Guinness World Record-holding stuntman, Dar Robinson. The contrast between those two lives perfectly illustrates the devastating cracks in the social safety net. Dar Robinson was an absolute icon of action cinema during the 1970s and 80s. He broke 19 world records and set 21 world's firsts. He was a true innovator, famously inventing the decelerator dragline system that revolutionized high-fall stunts in movies like Stick and Sharky's Machine, allowing cameramen to film a top-down view of a fall without relying on visible airbags. He jumped off the CN Tower in Toronto for the film High Point, executing a 700-foot freefall that cemented his status as an industry legend. He even dropped 311 feet from a helicopter without a parachute. His entire career was built on meticulously calculating risk and ensuring safety. He was famously the highest-paid stuntman in the world before his tragic death in a motorcycle accident on the set of Million Dollar Mystery in 1986.
Then you look at his son, Landon, who suffers from severe documented psychiatric disabilities, including bipolar 1, borderline personality disorder, and post-traumatic stress disorder. Landon applied for disabled adult child benefits right at the threshold of adulthood. Yet despite multiple administrative law judge approvals, he has spent years living in a tent on the streets, caught in an administrative labyrinth, where his legally approved benefits are continually diverted away from him.
Let us unpack the mechanics of that specific program because the bureaucratic framework is essential to understanding the failure. The core premise is that if a child develops a qualifying disability before age 22, they can continuously draw from their retired or deceased parent's social security record. It prevents a scenario where a person who never had the physical or mental capacity to enter the workforce is left entirely destitute when they lose their parental support.
The technical execution is where the vulnerability lies. When Landon turned 18, his minor survivor benefits should have smoothly converted to disabled adult child benefits based on his extensive medical records. Those records included early special education programs, an individualized education program, and time spent in institutional foster care. His federal file received the C1 coding, confirming his legal entitlement under his father's extensive work credits. However, an obscure provision called the Mother in Care benefit activated instead.
That provision allows a caretaker, in this case his mother, to receive the funds on the condition that the disabled child remains in their direct care. The glaring discrepancy here is that Landon was living in California, attempting to survive independently while the funds were actively routed to Hawaii. The system continued to distribute the money without verifying the living situation of the actual disabled dependent.
That points to a massive systemic failure in geographical oversight. If the Social Security Administration possesses the data showing the claimant and the payee reside in completely different states, the disbursement should trigger an automatic audit. Instead, the burden of proving the administrative error falls entirely on the disabled individual, who often lacks the financial resources, legal knowledge, or cognitive stability to navigate federal bureaucracy.
Bureaucratic inertia plays a massive role in keeping these errors entrenched for decades. Once a payment structure is established, altering it requires overcoming immense institutional friction. Landon attempted to work multiple times, taking on jobs with heavy physical demands, but he could not sustain employment due to his severe psychiatric conditions and physical tremors. Years later, completely unaware of the benefits being paid out under his father's record, he filed new applications under his own sparse work record. This triggered a bizarre legal and administrative sequence. His attorney took the case to federal court. The case, Robinson versus Saul, was officially documented in the District of Hawaii in 2021. the federal judge reversed the previous denial and remanded the case, leading to an $11,000 payout in Equal Access to Justice Act fees directly to his attorney. That Equal Access to Justice Act fee award is the smoking gun of the entire narrative. The government only pays those specific fees when the claimant prevails and past due benefits are officially acknowledged by the court. They essentially conceded his entitlement on the record, yet in processing the remanded claim, the agency assigned him a closed period of disability for just one single year, from August 2016 to September 2017, directly contradicting the very nature of a continuous childhood disability. A closed period legally implies a claimant fully recovered or returned to substantial gainful activity. Neither of those things happened. Landon remained severely disabled, later surviving a tragic suicide attempt and a 10-day coma following a medical crisis in 2024. The contradiction of a closed period existing alongside a lifelong C1 entitlement is what finally initiated internal audits. But the administrative tangle only grew tighter. A highly controversial maneuver, sometimes referred to as a double flip, allegedly occurred within the payee structure. After the mother's senior benefits capped out the family maximum under the father's record, the system allowed her dependent, her senior boyfriend, to draw from Landon's own work record. This effectively zeroed out Landon's available funds across both accounts.
The system acts like a financial shell game. The funds exist, the entitlement is verified by federal mandate, but the actual disabled beneficiary never sees a single cent. It forces us to question the incentives of the legal representatives involved in these complex disability claims. Disability attorneys operate on contingency, usually taking a percentage of past due back pay. If an attorney secures a closed period, it generates a neat, immediate lump sum from which they can extract their fee, leaving the claimant without the ongoing monthly support they desperately need to survive.
The legal framework practically incentivizes that exact strategy. Pushing for continuous, lifelong benefits is a protracted, difficult battle against federal lawyers. Settling for a closed period is a path of least resistance that guarantees the legal counsel gets paid but completely abandons the client's long-term interests. Landon was left with no ongoing income and no legal representation willing to untangle the subsequent mess because the maximum allowable fee had already been extracted. He was never advised on vital programs like expedited reinstatement, which allows benefits to quickly resume if a work attempt fails.
Beyond the closed period error, the bureaucratic machinery also faltered in its basic vocational assessments. The agency utilizes strict matrices to determine if someone can return to their past work, but if the data entered into that matrix is fundamentally flawed, the entire judicial decision collapses.
During his periods of attempting to work, Landon held jobs with significant physical demands, primarily as a restaurant busser. According to the Dictionary of Occupational Titles, a busser is classified as medium exertional work, requiring heavy lifting and constant physical movement. However, the administrative judges misclassified his past relevant work as a waiter, which is considered a much lighter exertional job. Because his physical and psychiatric limitations, including severe hand tremors, prevented him from performing medium exertional labor, a correct classification would have supported his disability claim. By downgrading his past work on paper, the agency falsely concluded he possessed the physical capacity to return to employment.
That kind of data entry error seems minor to a clerk, but it is catastrophic for the claimant. It artificially inflates their presumed capacity to